Hey, I hope you're ready for an incredible show, because today it will be an incredible show. I have a guest who is probably one of the busiest people in this county. He also happens to be a writer. And today is a special day for our county and for him. But we were able to get him. We are filming on Election Day, and our guest, unbelievably, is the Honorable John Sweeney.
Vinny, it's a great pleasure to be here. Thank you.
It is a pleasure to have you here. Well, this is called Let's Talk Writing. We're going to talk some writing, but we want to talk John Sweeney first. Tell us a little bit about who you are.
Well, I can give you all my titles to start with, but it'll probably take about half your show. That's mainly. I'm a justice of the New York State Supreme Court. I'm also a senior associate justice of the Appellate Division of the New York State Supreme Court. I'm also the senior resident justice of Putnam County.
Wow.
As I said, I have a lot of titles.
Oh, yeah.
And I've been a Supreme Court judge now, an elected Supreme Court judge for 14 years. I've been a trial judge for over 26 years, starting in Putnam County back in 1987. And I've been on the Appellate Division of the State Supreme Court since 2004.
Wow.
I was appointed by a Republican governor and made a senior judge on that court by a Democratic governor.
Now, today you are running for election again, but the last time you ran was 14 years ago?
Yeah, I was much younger then, yes.
Well, you look younger now.
Bless your heart.
Writing. Does writing have anything to do with being a judge?
Especially for what I do as an appellate judge, it is my life. My life as an appellate judge is reading and writing. As I said to somebody once when they asked me, what do I do for a living as an appellate judge? I say I get paid to study law.
Wow.
Because appellate courts, by definition, handle every kind of case that comes in, every kind of civil case, commercial case, criminal case, family, surrogates, you name it. We have them. And what we do is we review the work of the trial judges, which is the Supreme Court, which is the highest trial court in New York State, the family court, county court, surrogates court, court of claims. We review the work of the judges. We review the work of decisions that are made by juries or judges, depending upon the nature of the case or the nature of the application. And we decide, in fact, if there were errors made, if, in fact, the law was misapplied, if the facts were misunderstood to the law as it should have been applied in that instance. We do that by reading. We read the decisions of the judges. We read carefully through all the cases that were presented in the actual trial itself. We are given briefs by the attorneys, what they consider to be the applicable law that we have to take into consideration in making our decision. We read the pertinent parts of the record, which means all of the filings that came in on a case, be it a motion or a trial. We read through all of that. That's the reading part. And then after that, we have to write. We have to make a decision in terms of was the trial properly conducted? Was the motion properly decided? Things of that nature.
So take me to the moment. Now you need to write up everything you've heard. You spread it across the table? What do you do?
I should probably first describe why is it that, for instance, on a case, Judge Sweeney is writing the decision as opposed to Judge Jones or Judge Smith.
So you don't all do the same thing?
That is correct.
Oh,
that is correct. In my court, we sit about, we have oral argument, what we call it, or we sit as a panel of judges, 5 judges in our panels. We sit 4 times a week. Each judge sits one time during that four days, and he or she is responsible for 20 cases a week. Wow. That's where the reading comes in, to get ready to prepare for the actual cases, especially if there's oral argument where the attorneys come in and they want to argue particular points as to why they're right or the other side is wrong. We have something called a reporting judge. During the course of the oral argument, when we're on the bench, there's a special system which the clerk's office has, usually done by computer now, where a particular judge is assigned to each case. That makes you the reporting judge on that case. So when we go back to conference, which is immediately after oral argument, we will then go 1 through 20 on the cases we have, and depending who the reporting judge is, that judge will say, well, I think we should affirm, I think we should reverse, I think we should modify, and so forth, and here's why. That judge leads the discussion. That judge is responsible for the initial writing. In other words, let's say everyone agrees to affirm. That judge will write the affirmance, or everyone agrees to reverse, and so forth. Let's say that judge agrees to affirm, but another judge says, no, I think we should reverse here. I think the judge was wrong, or I think the law was misapplied. I, as the reporting judge, would still make my writing. The other judge will then respond to my writing with his, we call dissent, assuming he's in the minority, his dissent saying why I was wrong and why we should go the other way. I'll then, depending upon the case, I may respond to him and he or she will respond to me. We could do that once, twice, three, 4 times till we finally agree what our final writings will be, and then a final vote is taken of the 5 judges on the panel.
Wow.
And whoever, for instance, let's say I was in the majority at the outset, and then my colleague's writing is so persuasive that the majority switches over to him, I then have to change my writing to a dissent, and his or her writing becomes the majority opinion.
Wow.
But it's different with every case, it's different with every panel. We have 20 judges on our bench when we have a full complement of judges, and we sit in panels of 5, as I said, so you never know which 5 judges you're going to get.
Wow.
And in that, you don't know which judge is going to be a reporting judge in which particular case.
And then the buck stops there.
Absolutely. When the final decision goes out, that's it. Now, again, it may be, we'd like to have unanimity if it's possible. It always looks stronger that way. I think it's better for the attorneys if they say, well, this unquestionably is what the law is going to be on this point, because all 5 of them agreed. But by the same token, if someone strongly feels, no, I can't agree with that, I want to write a dissent, or we have something called a concurring opinion, which is, I agree with Judge Sweeney on what he's doing on that particular case, but I agree for a different reason.
Oh.
Or I think the particular point he relied on is not really the reason why we should affirm on this case. So I'll write a concurring, which means I'm still voting with Judge Sweeney, but for a different reason.
Oh.
And so we'll have concurring opinions, dissenting opinions, majority opinions. And it's important for us, if I can talk a little bit about the importance of the appellate writing in that regard. Because, for instance, as a trial judge, which I was a trial judge for 17 years on Supreme Court, Family, County, and Surrogates Court here in Putnam County, when you write a decision, that decision counts in your case, and your case only. So let's say I, Judge Sweeney, am writing a decision on Putnam County, New York State Supreme Court, but in Putnam County, and I say, for instance, on a contract case, I say a particular clause means that the buyer is obligated to do something. One of my colleagues in Westchester County could have a case with the exact same clause in it, says, no, 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 it means the seller's got to do something. So you go back, and so what that means is in Putnam County right now, my case holds. In Westchester County, that judge's case holds.
Oh, wow.
But another judge in Putnam or Westchester could say, I don't agree with either one of you. I think it's, the third party's got to do something. That case holds for that judge. But when you go to the appellate division, when those cases are appealed, and the appellate division issues the decision, that's it. The entire judicial department in which that appellate division sits, that is the law. And now the judge in Putnam, judge in Westchester, regardless of what their feelings are, they must follow what the appellate division has decided.
So your decision becomes law.
Absolutely. That's why what we write, it's so important to understand how precise we have to be, how exact we have to be, because the lawyers and the clients are following our decision.
Right. People are going to have to come back to that and look at that in other cases?
Absolutely. Absolutely. We are now the law of our department as far as that goes. Now, of course, our case might get appealed to the highest court in the state. The appellate division is an intermediate appellate court, which means we take the appeals from the highest trial courts of the state. There is one court higher than us, the Court of Appeals, which sits in Albany. They can take a case from us under certain circumstances. For instance, if there are at least 2 dissents in a case, they will take it. If there's a straight law question or a constitutional issue, they will take it. As a practical matter, perhaps 95% of the cases we decide stay in our court. But of those 5% that go up, then the Court of Appeals can make their own shot on it.
So tell me about the writing process. Now you sit around round table pretty much, right? You sit with these other 4 judges?
Actually, it's a rectangle, but it's the same idea.
Same idea. So you sit around and you listen to each other.
Exactly.
And then you have the law briefs too that you.
Correct.
So you have to take all of this conversation and you have to take these law briefs, and then what? You sit in front of a laptop, a desktop.
Well, again, understand that when we go to conference, which is right
Right.
after we sit on the bench for oral argument,
Okay.
we've done all our reading at that point.
Okay, so
we
it's done.
couldn't understand where we are. Now, there could be, for instance, you hear something at oral argument, and you say, wait a minute, I didn't think of that. That's a very good point. Or that would say point 4 or 5 in their brief when you think point 1 is the most important. But you say, that's a very important point. I think that's got to be looked at further. What you can also say is, I'm not sure now. I want to hold off. I want to go back and read these briefs again, and I want to look at the record a little more precisely, because there's something here that I'm missing or something here I'm not sure of. So you can do that as well. But again, it goes back to the judge, the reporting judge, who's got to start the initial writing. And the fact is, you do that by yourself.
Okay.
All 5 people have given their opinion. All 5 people have said, I think we should do a reverse or affirm, but we should do it for this reason or that reason, and here's why I feel that way. But you still have to go back by yourself to your chambers.
Put it all together.
And put it all together.
That's serious.
It is. And now some cases are resolved very easily in terms of what we call memorandum decisions, 4 or 5 paragraphs. That's it, and the case is over. Others you may be writing because the issue is so important, it's unique, or it's not clear to the rest of the state, so you could be putting 20, 30, 40 pages out.
What about issues? What are you deciding here? Is it anything from burglary to murder?
Appellate Division does everything. We take cases from the highest trial courts, and I mentioned what those were before. They cover the gamut of what we do in New York law. We do commercial work. In fact, I sit in the Appellate Division First Department, which is in Manhattan, so it's Wall Street. So we get an awful lot of commercial work down there, contracts, financial matters, and so forth. Probably the plurality of our civil side is doing commercial work. But we also have your personal injury, malpractice, products liability, contract.
Could be anything.
We also have criminal, the entire gamut of criminal, as well as the family and the surrogates and so forth.
Wow. So you've stopped banging the gavel a little bit, but you still do some gavel banging, yes?
Well, I prefer to call it presiding over trials, but yeah, I get your point. In fact, I've been a trial judge. I come back every summer, in fact, and when the appellate courts, all the appellate courts, and the U.S. Supreme Court on down, don't take new cases in the summer. The idea is the summer you're supposed to finish up your writings.
All right.
What I do is I come back up here to what we call the 9th Judicial District, which is the 5 counties north of the Bronx, and I volunteer to do trial work, and I volunteer to do divorce work.
Wow.
Because nobody wants to do divorce
Yeah, divorce work's tough stuff.
It is tough stuff, but it's very important. I think it goes back to my years in the family court, because I realized how important it is, especially my most important issue, the biggest thing for me has always been the protection of children. And I want to see to it, especially in a divorce case, if you want to mess up a child really well, have a contentious divorce.
Oh, yeah.
So I take them, I think I'm good at them, I know the law, and I certainly have the experience as a trial judge. So I come back, usually go to Westchester where they have the biggest volume and the biggest backlog to help out there. And I do the trial work. Number one, I like to do it because, again, the importance, I think, of protecting the families in a divorce case. Number two, it helps out with the backlogs. And number three, as I said before, one of the things we do in the appellate division, we're responsible for reviewing the work of the trial courts. Were mistakes made? Should you have gone a different way? Did you apply the law correctly? Did you apply the correct law? I never want to lose what it feels like to be a trial judge. So when I'm reviewing the work of a trial judge, I understand what he or she went through. I understand the pressures. I understand the time constraints. So I can have a better context when I'm making my decision.
I do a lot of investigating, mostly history investigating when I do my writing. And it's interesting because the information that I get is usually written, and it's been written for a number of years. But I have to take a little piece from here, a little piece from there. There's contradictions all over the place. I try to imagine your position of listening to a lawyer who's really good, a lawyer who knows how to state his case. Is it difficult to sort through and say, I've got to focus on the facts of what this man is saying, or this woman? Is that difficult sometimes?
The key issue is finding what the major points really are, because the lawyers may try to argue, Judge, we really should be deciding this case based on this, when we know, no, it should be based on that. Now, unfortunately for you, counselor, this helps you, that doesn't. But that comes with experience.
Yeah,
and again, that comes, I've been a lawyer for about 35 years. I've been a judge for about 26 years. Wow. And that just comes with the tens of thousands of decisions I've done. You learn to find what the key issues are. This goes back to what I was talking about before. We get 20 cases a week. Wow. And those are, most of them are very heavy, especially the commercial cases. You're talking pages upon hundreds of pages of briefs and records and financial charts and things like that. You have to know how to get directly to the issue that's going to decide the appeal.
That's exactly right.
And sometimes it means getting around what the lawyer wants you to look at.
And what you're doing is you're creating pretty much an opinion paper, a position paper. When you're done here, you have to take all of these things, weigh them, get them down. So is there a method to this? I mean, Do you state right off the bat, affirm?
It depends on the judge. My position has always been, especially if I'm writing something that's going to be long, 20, 30 pages or
You're
so,
right.
I don't like to write, number one, I don't like to write long decisions. I think the shorter the better. Get to the point.
Yeah.
And when I get to the point, I usually start with my first paragraph. I'll say basically affirm, denied, or affirm,
Great.
reverse, whatever it may be. I don't
then
want to make
support
people
it.
wait 20 pages to find out what the end of the story is going to
Right.
be. Then I go on and I spend the next 20 pages explaining
Yeah.
why I said at the outset, affirmed or reversed
Mm-hmm.
or whatever. But again, what you have to do with this, for instance, I know you've got a later show coming up with a rabbi.
Yep.
And sometimes I feel like we're Talmudic scholars in the appellate division because we will literally come down. Because our writings, again, what we write is now the law that applies in the entire department. All could be hundreds of trial judges have to follow what we've done.
Wow.
So we have to be precise so the trial judges can't look at it and say, what do you mean by that? Wait a minute, can I do this or can't I do that? They have to know as fairness to them. And in that, in fairness to the attorneys who will be presenting subsequent cases, this is what the law is. And I was joking about being the Talmudic scholars. Sometimes I had a case once with one of my colleagues. We're arguing whether a comma or a semicolon should be used. Was it an independent thought or was it just a continuation?
Yeah.
Things like that,
Yeah.
because it made a difference in terms
Yep.
of the significance of the actual
Absolutely.
writing.
I mean, you're not doing fiction here, so you can't kind of like
Unfortunately,
go off.
no. It'd be a lot easier if we
No.
did.
So you have to be very careful about not only what you say but how you say it,
Exactly.
and that's crucial. So it is a writing skill. Now you've been at this job 14 years.
As well, I've been an elected Supreme Court judge for 14.
This particular position that you're in right now.
I've been an appellate judge for about 9.5 years.
9.5 years.
Right.
Now, does it get easier?
It was interesting because when I first went on the bench to the appellate division, there was a judge there, Joseph Sullivan, who was called the dean of our court. Brilliant man, brilliant writer. And first thing I did was go to him, ask for advice. And I
Great
said,
idea.
Joe, I'm new here. I mean, and this is a totally different style of writing. It's a totally different style of approaching a case, a totally different lifestyle, because we're not dealing with clients and lawyers and settling cases anymore. We're just deciding legal issues. And one of the things he told me was, you're not going to be comfortable here for at least 3 years. It's going to take you that long to really appreciate exactly what an appellate judge has to do and how he or she has to approach the job.
Yeah, I tell new writers, always write from the heart, but look at the people who've come before you. And think about that. Somebody like Steinbeck wrote 117 pages in the Pearl. And those 117 pages have lasted for years. What did he do with the same language that we have that made that a classic? And how does that differ from what we do? Writing is an art, and you have to know exactly how to use the language. You have to be careful, and you have to be able to take things out here and narrow them here. And it just blows my mind when I try to think of what you do, where you take all these pieces and put them together. It's difficult. It's not an easy job to do. What is our time frame? I mean, how much time do you have? Do they say, okay, you need to write this up, you have 2 hours? No. I mean, how much time do you really have?
We have an unwritten rule in our court that your cases, all decisions should go out within 90 days.
Wow.
And that includes, again, let's say I'm writing, I'm the reporting judge, and I say we should affirm. And you're on my panel, but you say no, we should reverse. That 90 days includes my writing, your response to it, my response to you, and so forth. How many responses we want to do until final writings are done, so we can ask for a vote from the 5 judges.
So, do you get to talk to me about it?
That's an interesting point. It's always been said in appellate judges you should never lobby for a vote, which means, for instance, let's say you're not sure how to go. We had the conference and I said I want to affirm, and you're there saying, John, you might be right, but I'm not really sure. The wrong thing for me to do is go to you and say, oh, Vinny, come on. Vinny, here's all the points. Come on, Vinny, you got to go with me on this. That's absolutely wrong. Because what I'm now doing is trying to take over your independent thought, how the case should go. I will send you writings, and I'll say, Vin, please take a look at this.
Writings.
But you'll draft decision and say, Vinny, can you go along with this? And you'll write me back saying no, or you could say, John, I'll go along with you, but I think you're being too harsh on the trial judge for this particular point, or I think you should emphasize this area of law a little bit more, then I can go with you. That's fine. because we're doing that above board. Everybody sees the writing I'm sending to you and the response you're giving to me. And so you may not want to, you may say, I'm going to go with you after all, John. Or you may say, no, John, the more I think about it, this is totally wrong, the direction you're going in. We've got to go this way instead. But again, that all hopefully goes in within the 90-day process. Are some cases held longer than that? Yes, they are, because some judges get into, you have like 2 or 3 judges start writing. Again, I mentioned a concurring opinion.
Yeah.
That turns into a real mess, because then you've got to get all the writings down, then you've got to get the votes from 5 judges on 3 writings.
And there's no such thing as a hung jury.
Absolutely not. A case will often have something sometimes where, for instance, you can have, say, 2 votes to affirm, 2 votes to reverse, 1 vote concurring, which I'm not really sure which way he's going on that. But the fact is, what he's saying is basically, I'm not sure if either one of you guys are right. Maybe we should go back for a new trial or something like that. That pretty much means the trial judge's decision or the jury's decision is going to stay as it was, because we had nothing definitive to say reverse or affirm. That's very rare, though. Very rare we have that. Usually, as I said before, you want to be precise, you want to be exact, and it's either going to be affirmed or reversed.
And one thing you said before that rolls around in my head, a lawyer's brief. Now, if you read a lawyer's brief and you say, you know, I don't know about this, you can't really go back to the lawyer and say, hey, let's have a talk about this.
That's right, absolutely. The only way you get to talk to the lawyers is oral argument. And oral argument can be a great tool for the judges as well as the attorneys, because the attorneys want to emphasize particular points to you, and the judges may have questions about certain things which weren't clear from the briefs. They may have a question about how something was presented to the trial judge, which is not clear from the record that we were been given. That's where you have the chance to exchange ideas. The problem you run into that is that you cannot go into matters that are not on the record. For instance, you can say, well, why didn't you do such and such at trial? Judge, that's not part of the record. We can't go into that. Okay, fine. That's the end of that. Also, an interesting thing about oral argument, one question we always get from lawyers, does oral argument change our opinions? Because again, remember, we've done all of our reading before we go and sit down for oral argument. So we pretty much have an idea where we want to go. And the answer we usually give is oral argument will change maybe 10 to 15% of the cases. In other words, we go in thinking, well, I'm going to affirm. And you hear oral arguments and no, wait a minute. Oh, that's a very good point. I'm going to reverse. Or even if it doesn't change your opinion, it clarifies your position. It gives you a much more precise idea what the lawyers were getting at, so it solidifies in your own mind why you want to affirm or why you want to reverse.
Wow. Yeah, that's a good point. I was wondering about that, you know, where you go in and you're like, man, there's no question about this. And then by the time you're done, there is a question.
And that's where it comes, you were mentioning before, you get to hear some really great lawyers, which is something we do in the appellate division, because especially in the heavier cases, what I'll call the heavy commercial cases or something like that, but where they're paying top dollar for the people they're bringing in, you get some outstanding attorneys. And it's fun. It really does. You're asking questions at times, but sometimes you're just sitting back and watching their thought process work. And it's really a great thrill for a student of the law, which is, again, is what we are, to hear that and to have that presentation made.
It's what I say about teaching. You know, I used to say one thing I loved about teaching the most was being a student.
Sure.
And you're a student all the time.
Absolutely.
The students are teaching you as much as you're teaching them. And there's so much to learn day by day. I taught for 35 years. I still have another 35 years of learning to do. You just never stop learning. So here's a big question for you. Did you pick the right profession?
I think so. You're talking about history before? My second choice was to be a history teacher.
Oh, yeah. I love history.
And it's the old joke, why did I go to law school? Because I had nothing else to do, which is basically what it was for me. I wanted to be a history professor in college, and when I graduated from college way back when, at the time they said there were 25 graduating PhDs for every opening. And I said, gee, I think I'll go to law school. Sounds pretty good to me. So that's why I became a lawyer.
Yeah, there you go. And and the writing end, how did you prepare for that? What was your major?
I was a history major.
A history major.
And that was the interesting thing about it, because liberal arts, the danger of being a liberal arts major, of course, what do liberal arts majors do in college? Oh my goodness, I've got a 20-page paper due tomorrow. I forgot all about it. So you sit down and 20 pages, 10 minutes later you got 20 pages.
I know.
Not exactly.
That was the part I loved. You know, we had choice. When I went to school, they said, you have a choice. You can either take an exam or write a paper. I was like, yes, paper! I loved the whole idea of getting all this information and pulling it all together and ending up with a solid body of information that's kind of yours and all of theirs.
But the problem you run into that is the fact that liberal arts majors, as we well know, tend not to be as precise, perhaps, as they should be. Because you got to fill those 20 pages somehow.
I know.
As the lawyer, you can't do that. My dad, who's a Supreme Court judge, always had the position that the best training for law school was not being a liberal arts major, which most of us were, but being an engineering major or a science major, because they have to be precise. They have to deal in absolute fact. They can't let their minds just start to wander. And that is what you have to do as an attorney and as a trial judge, but most especially as an appellate judge. You've got to be precise because every word counts. Every word's going to be examined. It's going to be examined in the context of the phrase. Again, we go back to our semicolon versus our comma. It's going to be examined in the context of the entire decision. Because lawyers who don't win on your decision are going to try to pull pieces out of it to say, well, I know, Judge Sweeney's opinion said black, but I think we could probably, another factual situation, maybe we can get white out of that.
But can they come back, and after you've made your final decision, can that lawyer come back and say, Judge Sweeney was wrong, and I want another opinion?
What you can do is ask for a re-argument. Re-argument you have in the trial court, and you also, excuse me, you also have it in the appellate division, which basically means I believe the court overlooked pertinent facts as they apply to the law. And you can ask that. It is rarely granted, because our position is we work very hard on these cases. We think we're right the first time. Thank you very much.
There you go. So now, the biggest question of the whole interview. Ready to write a book?
Oh my God, no. Number one, if I wrote an autobiography, everyone would go to sleep after the third page. And number two is, with all the writing I do for a living, thank you very much. No, I think there's not a book in me, as they say.
Well, I'll tell you what I think. You were a wonderful guest.
Well, thank you very much.
It was certainly a pleasure to have you here. I wish you well. As we said, today is Election Day. Looking forward to having you continue doing a wonderful job for all of us. I know you're hardworking. I know you mean well. And I know you've been a great service to all of us.
Danny, thank you very much.
Thank you for being here. Thank you for being here. I appreciate having you tune in. We have many good guests still coming, but this one was terrific. Thank you for being here.